Yes, what I pick up is very clearly that CBDT has taken in cognizance the representation made by the FPIs. Very clearly, I also mentioned earlier when I broke the story that FPIs have made a detailed presentation, and DEA is asserting the fact that yes, FPIs have a merit in their argument, and it is only an interpretation issue. If the interpretation is clarified in detail, then probably the concerns of FPIs can be addressed in a much easier and clarificatory manner. Very true, the government is very clear that they don't want to do with any sort of a clarification which leads to tax terrorism. The idea of CBDT putting the circular in abeyance is very clearly the fact that they want FPIs to pay tax only once. Now, what I'm picking up is also, which is very crucial right now, is the fact that CBDT wants a detailed discussion with the stakeholders, that is SEBI, that is FPIs and DEA, once again before they come out with a perfect clarification for this matter. Very clearly, also the point which let me remind you and our viewers very clearly is the fact that FPIs, while making the presentation, they said this could lead to a triple tax on them, and and under the DTA route, you can be taxed only once. Now that grandfathering is also going to be there, there are further amendments in the double taxation avoidance agreement. It itself, the nature of DTAs itself is the fact that you cannot be taxed twice.
Okay. Well,
you will
Timsy,
be taxed only once.
I get your point, Timsy. Actually, we are being joined by Mr. Dinesh Kanabar, who has elaborated on this circular on our channel itself. Mr. Kanabar, what we have heard from the CBDT now, and it is official, is that circular on indirect transfer and its taxation, which was put out by the CBDT on December 21st, has been held in abeyance until clarification is made because of representation that the CBDT got from foreign investors. Your comments, do you think that this is the first step to perhaps moderating the impact of that, moderating the influence of that circular altogether?
You know, Lata, it's a very, very positive move. The way I would look at it candidly is that we had an amendment to our law which got interpreted in the circular. As I had mentioned to you earlier, Lata, this circular really does nothing but elaborate on the law as it stood. But the representations were that the amendment was made to cover a particular set of circumstances and not the set of circumstances as were set out in the circular. And therefore, it was a retrograde step. And I am glad that saner counsels have prevailed. I must tell you, Lata, from a business perspective, I've been talking to a number of FPIs, and there has been a deep concern about this circular, and I'm glad it has been kept in abeyance.
Mr. Kanabar,
what is more necessary?
Yeah, Mr. Kanabar, you know, since we're beginning this conversation in the middle of the event, as it were, if you could lay out from in lucid terms what was the law, why it came into being, you know, because of the Vodafone case, and I mean, if you can just explain the backdrop and therefore give us perspective as to why this circular seemed to be overstepping the limits of the amendment.
Sure. So, in the context of Vodafone, briefly, we had an overseas company with an underlying value in India. And the question was, if shares of the overseas company were transferred, were the gains liable to tax in India because the underlying value was in India? Supreme Court said no. And the Income Tax Act was amended retrospectively. And the retrospective amendment did not say that such a transaction is taxable. But it, however, went on to say that a foreign company, if it has got substantial assets in India, then will be treated as an Indian company. Therefore, a foreign company with more than 51% assets in India would be regarded as an Indian company, and therefore, if the shares of that company were transferred, that would be liable to tax in India. Now, we came up with a set of exemptions to that rule, which was to say that if there is a 5% tax, a 5% shareholding, it will not be regarded as taxable, etc., etc. But each of the exemptions went away from a specific thing, that the way to address the Vodafone issue was not to deem a foreign company to be taxable in India. So then we had a situation to say if dividends are declared by that foreign company, again it will not be taxable in India. So you first put a wrong framework and then you go on providing for exemptions to cover up the framework itself, which is wrong.
Okay.
Now, just coming to the current situation and what is really impacting. So take a fund based out of, say, Singapore, making investment in listed equities in India. Its gains are tax-free.
Yes.
Let's assume it's a broad-based fund, but there is somebody who's holding 7% equity in that fund. If he redeems the shares or his shares are transferred, those are liable to tax in India. And that was really never intended.
So,
it was only when a controlling stake in an Indian company got transferred, a la Vodafone, that was intended to be covered.
So, Mr. Kanabar, do stay on with us. We have Mr. Ketan Dalal also joining into the conversation. Sir, so the circular stands in abeyance. That's what we know right now. I just want to bring out the point of this 5% carve-out. Essentially, the circular had the exemption granted to people who own less than 5% equity of this AMC or this India-based fund. This was already raised in question number 11. So the CBDT circular originally said that the 5% threshold is reasonable for excluding small shareholders from the ambit of the indirect transfer provisions. That's the view that the CBDT had while drafting and putting out the circular. So what is it that you'd like to say to the chairman of the board? Because this is in abeyance. There will be a final clarification coming in. So as they decide on that final clarification, what would you like to put before the board?
Yeah, so Surbhi, as Dinesh mentioned, I think the idea was to tax an overseas company transfer of a controlling interest stake in India or something which is similar to a controlling stake. But the other point, which I think I would like to bring out, is it is not just that controlling stake, but the controlling stake presupposes that the transfer at the overseas level must be by somebody who himself is holding a substantial stake.
Yes.
So the intermediate company may be holding 100%, but the guy on top or the company on top or the fund on top, or sorry, the investor on top of the fund may be holding, say, 7% or 10%. And that can't be deemed to be the transfer of a controlling stake in India. Now, coming to the point which you raised, Surbhi, regarding the question number 11 and the answer there too, I think what happened was that the committee which had sort of been mandated to address the representations was simply trying to articulate the position in law in the literal sense, as opposed to saying that, well, the law itself needs a change. So I think it appears to me that the recent clarification, which I haven't seen but which seems to have come out today in your breaking news, seems to say that we will keep this in abeyance, which to my mind is perhaps an indication that in the forthcoming budget, which is now just 12-15 days away, they will probably amend the law, because this can't be done through a circular, because the law does talk of 5%.
Okay. So chances are you're expecting the clarification in the budget. Okay, I was expecting that they will do it outside the budget. But how do you think they will clarify? Would they say that this tax will be applied if a person owns, say, 26%? What kind of a clarification or amendment will set matters right?
So, Lata, as you said, 26% to my mind, well, I would hope that it is 51%, because to me, it sounds to me that 51% should be a good threshold. But I would say that the minimum they should do is if the investor on top of the offshore company is holding at least 26%. I mean, 26% is also sort of a normally accepted benchmark, let's say, for special resolutions. Not that this has anything to do with passing special resolutions, but it is a reasonable benchmark. And I would say, while I hope that it is 51 at least, but at the absolute minimum, it should be 26. And I suspect that something like that will emerge.
Mr. Kanabar, let's extend this to what happens to certain feeder funds which are putting in money into India dedicated funds, fund of funds, these additional structures. What is it that you think would be a fair sort of taxation regime? Also, let's, also play devil's advocate and look at it from the government standpoint. They want to ensure that if anyone is making substantial benefit or gain out of selling or buying Indian equity, should pay tax. So then when it comes to these slightly more complicated fund structures, what do you think would be a rational regime?
Okay, if I can just take a half a minute before that to the question of what is the framework. And one very simple framework, there was that government appointed SHOAM committee. And the SHOAM committee actually came up with recommendations on what should happen to Section 9. And they actually recommended 26% as being the limit. They also recommended doing away with that it should not apply to companies which are listed, etc., etc. So we have a government's own committee framework. And if that is followed, I think that would be first a very welcome step. Insofar as feeder fund structures are concerned, we have to go to the ultimate beneficiary. So if the ultimate fund is a widely held fund, the mere fact that it has created an intermediary structure should not be a problem at all, because a fund is basically treated as a transparent entity because it is by definition it's a feeder and therefore feeds into the parent fund. So again, these are structures which are not vulnerable to abuse. They are accepted globally, and I don't see that as a challenge.
Okay. So, Mr. Dalal, can we at least assume that since the circular has been held in abeyance in deference to the representation made by foreign investors, whatever comes after the reconsideration will be at least more benign than what we have in our hands now?
Yeah, I would think so. Certainly, I would think so, Lata, because I think the thrust of the representation was also to point out that this was never really intended the way it is. I think, first of all, whether it is, the example of the Vodafone case or other cases, the intent, as I mentioned at the beginning of this, was primarily
Mr. Dalal, just 1 minute, sir, because we have a stock market expert as well joining us. Since this is of so much importance to the stock market, Mr. Nirmal Jain, who is with us. Your reaction, Nirmal, that circular of 19 questions, was it? Yes, 19 questions has been held in abeyance. Does that give you a hope that things will change for the better?
So I think the circular had caused unwarranted confusion amongst the FIIs. And particularly those who are India-dominated or India-specific funds, because for them, if you start taxing them, then they become unviable, and most of them would not have been able to raise new money. And of course, they would have had embarrassing situations with their existing investors as well. So it's a I think, great relief for those funds, and in a way, it's a clarification was much needed. And as I say, that in the first place, our income tax authorities and government should work in tandem. And so this has happened in the past many times, that they issue circulars which create a lot of confusion, unnecessary volatility, and then clarification comes after a while.
So is there enough joy in this holding in abeyance of this circular for the markets to sprint as early as tomorrow?
No. That is difficult to say, because how does it impact, you must understand. So there are funds that are for India-specific funds.
Yes, they are more, I would assume it was only India-dedicated funds which would have been hurt.
So what would have happened, that those funds would not have sold because of this circular.
Yes.
But if you want to raise new money in those kind of funds, then it wouldn't happen. So what happens is this probably will have impact on the medium term. So suppose, there are many fund managers, and, Akash Prakash has written an article, his fund, and many such funds. So for them, it would have been a major disaster, and they would not have been able to raise new money. Or many people want to raise India-specific or India-dominated fund, they would not. It would not be viable for them. But if you ask what will happen tomorrow, it's difficult. Sentimentally, market may go up, but it's not that more money will just come in tomorrow itself from this. But it's good from medium-term perspective. And on one hand, and on the other hand, sentimentally also, foreign investors, whether they're India-specific or not, should have a clarity and stability of tax environment.
So Nirmal, finally, since you're saying it is sentimentally a huge positive, sentimentally, does it raise the expectations purely from a taxation standpoint from the budget?
I think, foreign investors, more than anything, they need clarity. And when we are competing for foreign capital with, other countries where the capital can flow into, obviously we have to be competitive on tax front also. So I think budget, probably a lot more expectations are there from corporate tax point of view, or from boosting private sector investment. Private sector investment cycle has not been reviving for quite some time, and that's a very important component of sustaining the GDP growth.
Absolutely.
And now that IMF has scaled it down, I think government will put in its best foot forward for that.
Now I guess we are extending our brief in terms of what we expect from the budget. Nirmal Jain, Ketan Dalal, Dinesh Kanabar, thank you very much for making this unscheduled stop at CNBC TV 18 and clarifying what holding in abeyance of this circular really means. India-dedicated funds which feared that investors into those funds could be taxed twice or thrice, could be victims of multiple taxation, would now breathe easy, and they will await more clarification from the CBDT. That's a positive. We had, of course, Jonathan Sheasel of Ashburton and Akash Prakash, that, like Nirmal Jain mentioned, getting worried that medium-term, view of India would get clouded. So that cloud dissipates for now.